Hello, everyone. Thank you so much for joining us today. We're really excited to have you here. My name is Shelby Hayes. I'm the marketing director at Evans and Davis, and I'm just going to kind of lay some ground rules for us, get us started, and then I'll hand it over to our attorneys for the session today. Today, we're talking about funding the basket. So we're really going to be covering those topics on how to make sure that the trust you set up really works the way that you want it to when that final buzzer comes. A couple of ground rules here. Thank you for being here. We do really appreciate that. I want to let you know that we can't see or hear you today. So I know that's a relief to some people. If you're eating lunch or doing whatever you're doing, you don't have to worry about making sure you're muted. But we do want to make sure you're able to ask questions. So please just look around on your screen. There's a chat button usually at the bottom of your screen. And that's how you can send us your questions. We want to answer all of those questions that you have as we go throughout this session. I always encourage people to send in their questions as soon as they have it. That way you don't end up forgetting by the time we get to the end. We have some great content. We'll take up about 30 minutes of your day, and then we're going to leave plenty of time here to get your questions answered after that and still get you out of here in an hour. We are recording this session, so if you love it and you want to share it with friends and family, or you want to go back and watch it later, we will send that recording over after we get done today. So let's start out with some introductions. Like I mentioned, my name is Shelby Hayes. I'm the marketing director at Evans and Davis. You'll be hearing from attorneys Mitch McCuistian as well as Ryan Raupe today. Mitch is one of the partners at our firm, a former athlete, so you'll probably hear lots of basketball talk, of course, but maybe
use that term. Use that term loosely, Shelby.
um, we'll call you that at least.
Sure.
Mitch went to Arkansas and then to the University of Oklahoma Law. And one of the things that I think you'll really appreciate about Mitch as we go through is his stories. He's one of the best storytellers I've seen in this industry. And I think that skill really allows him to be able to help us non-attorneys understand the topic a little bit better. So I think that will be a big benefit of today. And then we'll also be hearing from senior attorney Ryan Raupe. Ryan and Mitch work really well together, and both of them focusing on estate and business planning and working with clients each and every day. So they've seen all different types of plans. They know which ones end up working in the end, as well as the mistakes that they see people make. So you're going to get to hear a little bit about all of that. A few more kind of background introductory slides, and then we'll toss it over to them to get started with our main topic today. I know that most of you are familiar with Evans and Davis, but if this is your first interaction, welcome. Evans and Davis is an estate and business planning law firm. We're regional at this point with offices in about 16 states. You can see our team there. And one of the things that is very different about Evans and Davis versus most law firms is that all 20 of our attorneys are doing estate and business planning all day, every day. Most law firms, they'll have someone that does estate planning, but they kind of dabble in it. And that's different. Whereas our attorneys, they're seeing a lot of different types of plans and a lot of different types of families or businesses. And they're really getting to become experts in that field, spending all of that time just in estate and business planning. So with that, I will hand it over to these attorneys, Mitch and to Ryan, and we will get started.
All right. So what we want to accomplish today is, as we head up to the March Madness season, we've got all the conference tournaments going on, and next week is the Field of 64, which for me is 2 days of fun. It's always nice when you're drafting trust or doing whatever for a client and having that on the background, especially when my Razorbacks are on. So game plan for today is we're going to start with the tip off, and what that means in terms of when you initially set up a trust with Evans and Davis or a different firm. What does it mean to fund it on the front end? And then for the halftime, we're going to, life goes on. So as you set your trust up 3 to 5 years ago, where are we at today? What's changed? And so what do we need to do at the halftime point? And then, of course, the final buzzer. We're going down to the end. Hopefully we're lived a long, healthy life. And then we just need to make sure that it all works properly. So that's our game plan for today, to kind of, go through those steps and hopefully get a win at the end. So first, let's start with the tip off. The number one thing that we hear when we talk about estate planning, whether it's with another firm or a client comes to us, is really that initial funding of the trust mechanism. You can go down the street and some attorney that did a divorce at 10 or a car accident at 2 is going to say to you guys, all right, I'll do the trust for you, but the rest of it's on your own. And so that's not really much of a service, because what you're really buying is an expensive piece of paper that isn't going to apply. So on the very front end, at the quote unquote tip off, we've created this bucket. And then what we want to do is we want to move the stuff into the bucket. I'll literally sit in front of clients that have, I'll have clients that, have lots of money and lots of properties and lots of stuff. And they say to me, well, what is a trust? What exactly is it? And one of the things at Evans and Davis that we try to do is simplify what estate planning can be. And so when we talk about a revocable trust or a living trust or a family trust, they're all one and the same. And I think of it conceptually as, we've created this big bucket and we've got to put your stuff in the bucket, right? And so that's going to include a lot of things in terms of properties and different accounts and things of that nature. But you've got to think of it conceptually. Your bucket doesn't work unless we put your stuff in the bucket now. And as we'll talk about here in a little bit, continually to fill up that bucket over the course of time.
Yep. So as Mitch was alluding to, if you set up a revocable trust, but you don't put your assets into the bucket, it's really not worth the paper it's written on. And so most clients will come in with various assets, whether it's just a house and a bank account, which most people will have. We need to be sure that those assets are titled in the name of the trust. So here's a list of some common assets that most people will have, whether it's your personal residence, a vacation home, a lake house, beach house, whatever that may be. And then especially in Oklahoma and Texas, where minerals and mineral interests are so common to have, whether they're inherited or they've been purchased by you during your life, it's important that all of those assets are titled in the name of your trust or in an LLC or some other entity. And I'll touch base on that as we go on. Also, your bank accounts need to be in the name of the trust. That is super, super simple to do, but it's oftentimes overlooked. And then once somebody passes away, you'll have to go to the bank and they'll say, well, we need letters of testamentary. Well, what that means is that you have to have somebody appointed by the court to authorize them to get into that bank account and then distribute those funds accordingly. A few other assets are brokerage accounts. So if you have just cash accounts with mutual funds or a money market account, those accounts are post-tax and they need to be in the name of the trust as well. Again, this is all something that your attorney should go over with you during your initial meeting to be sure your I's are dotted and your T's are crossed. With life insurance, it can be a little bit different. We don't actually move the life insurance into the name of the trust. The clients still remain the owner of those life insurance policies. But again, we want all of the funds to funnel through the bucket. And so we update the beneficiary of the life insurance to the trust. Some people think that's a little bit weird, and they have a husband and wife have a little bit of hesitation with that because they say, well, aren't I supposed to be the actual beneficiary of the life insurance policy? Well, if it's a joint trust, most of the time, both of the grantors are the lifetime beneficiaries. We just want to protect for what if husband and wife have both passed, or if they pass at the same time. We don't want that to be a probatable asset. And then my last bullet point there is shares of your corporation or units of an LLC. You need to be sure that the trust is either the units of those LLCs are assigned to the trust, or when you are first setting up those LLCs, that the operating agreement lists the trust as the actual owner. So oftentimes, and this is kind of a halftime segment that Mitch will get into, but what if clients come in and you think your assets are already in your trust? Well, oftentimes they are. I would say it's probably 50-50 that trusts are properly funded, and then we go in 10 years later and we look and yep, they sure are. We just need to make a few tweaks to the actual trust document. That's fantastic. A lot of times what happens though is life happens. People buy a new home, they move states, they open new bank accounts, they find ways to diversify their assets, whether it's opening a business, buying rental properties, etc. And so the way to confirm that your assets are actually titled in the name of the trust is, one, for your real property, you can get on the county assessor's website. And if you can't find yourself via your individual name, it's probably in the name of your trust. Sometimes, like in Oklahoma County, they will list your trust as the actual owner, which is perfect. Bank accounts, your bank statement should say the Ryan Raupe Trust dated March 10th, 2022, or whatever day that you set that trust up. That's a great way to check if those bank accounts are in the trust. And then for entities, corporations, LLCs, check your operating agreements or your stock certificates to see who those units were issued to at first. Were they issued to you individually or your trust? And then life insurance statements, of course, they generally will have a beneficiary designation once you receive those statements. We just want to be sure that the trust is the actual beneficiary. A very, very common question that Mitch and I get is, what do I do with my boat? What do I do with my vehicle? Or, hey, I have a really nice watch that I want to give to my grandson, or my grandma's wedding ring, I want to give that to my daughter. How do I do that? So we have an assignment of personal property that just assigns your clothes, jewelry, furniture, what I call your stuff, to the trust to allow your successor trustee to distribute that property accordingly. There's also a personal property memorandum, which is great because you can update that by just handwriting on a separate document as life goes on. So if you purchase, a new watch in 20 years after your trust has been set up, you can just go in and fill that in and say, I want my watch to go to my son, daughter, grandson, whatever that may be. And vehicles is very common as well. If you don't retitle the vehicles into the name of the trust, that's generally okay. We certainly prefer the vehicles to be titled in the name of the trust, but generally we can do a small estate affidavit to to sell those vehicles and then distribute that money that way.
A lot of times vehicles, we're not your tax accountants here, but a lot of times vehicles will be titled in the LLC or the corporation. So it's important. And Shelby, if you go back for 2 seconds, one thing I want to hit on, and for Ryan to kind of touch on, is, guys, we can leave heirs money, you can leave them, business, but a lot of times some of the most important planning piece when someone passes away is, that the grandson got grandpa's over under shotgun, or the granddaughter got grandma's china, or whatever the case might be. Sometimes most of the important part of planning is the personal touches to where, gosh, that will always be mom or dad's, or whatever the case is. So don't discredit writing down 5 to 10 things and leaving those to heirs. Because Ryan, wouldn't you agree that, a lot of times when someone's passed away and we meet with those families, God, they talk more about the stuff than they do the actual money.
100%. They have more of a personal connection to something that they enjoyed with their parents or grandparents than just the actual money. I 100% agree with that.
Sure.
While we're talking about the assets that you should put into your trust, I also wanted to touch base on a few of your assets that do not go into the trust. So qualified retirement accounts such as 401ks, IRAs, basically pre-tax money, pre-tax accounts. We do not change the owner of those accounts to the trust because that creates a taxable event. We can designate the trust as the beneficiary of those accounts in certain situations. So if you've got young children, it's a good idea to probably have those funds roll through the trust. If we've got children with special needs and they might receive government assistance, or any kind of beneficiaries have supplemental needs, it's a good idea to leave those funds to the trust. Also, if you want to designate a charity as a beneficiary within your overall estate plan, it's best to do that via your retirement accounts, just from a tax perspective. If you list the beneficiaries in the trust, that's already non-tax money. And so it's a good tax play to list the charities as beneficiaries of those qualified accounts. Looks like we've got a few questions. Let's see.
So one of the questions we received is, we own some real estate properties in one of our entities that are under their name rather than their trust mechanism. My advice would be, we need to make sure we have an assignment of interest, to make sure that your ownership units in that LP or that partnership interest are actually owned by your trust rather than you individually. So in your partnership agreement or your bylaws and or operating agreement, let's make sure that the actual entity is the trust as opposed to you as an individual. Ryan, any other ones you want to go ahead and address?
Yep. I think we addressed the 401k.
So in basic terms, typically 401ks we do not put into the trust because those are pre-tax monies. And so we do not want to put that into the trust because that would be a taxable event. But depending on the age of the beneficiaries, we might look at incorporating the trust as a contingent beneficiary. But there's a lot of considerations to take into that.
There's a question regarding life insurance, death benefits, and are they taxable to beneficiaries if they go through the trust first? They are still not taxed to the beneficiaries if they go through the trust first. If you have an estate tax issue, which is a whole nother ball game and a whole nother topic, they can be taxed if there's an estate tax issue. But if you're under that threshold, which is about 12 million per person, then those monies are not taxed, even if they flow through the trust.
All right, so we're at halftime. We got our trust set up 3 to 5 years ago. Now we're at where we are today, and things have changed. I've bought more property. I've opened a new business. What do we do? How do we make sure this continues to work? And so we're going to spend the next little session here to talk about updates and common issues we see. One of the number one things that Ryan and I deal with is, well, I bought a new home and I forgot to put it into my trust. I would probably say, Ryan, you probably say about 5 to 10 times a week, we get an email from a client saying, didn't do it. Or mortgage companies.
In a new house, what do I do?
Yeah. So one of the things I want each of you to do, if you've done estate planning in the past, make sure we've retitled the real property into the trust. We might have done it 5 years ago when we did the initial planning, but maybe you've got to refinance and we put it back in. So that's the number one thing we see. Or you say, well, I'm going to go buy a investment property on 30A in Florida. We're going to set up a real estate holding company in Florida, and we're just going to go ahead and put the operating agreement, but I put it in Mitch's name. No good. You've got to have some mechanism, whether that was the operating agreement, naming my trust as the member, or me giving my units to my trust. We've got to make sure any new entities continue to flow through that bucket, because otherwise it's not going to be included. Same things go for new life insurance policies. Let's say that a bank requires you to pick up a life policy and we've got to collaterally assign it. Well, as the bank continues to release some of that collateral assignment, I want it to flow to my trust. So those are normal things that kind of are common issues that we see. And then the number one thing, I call this the 1970s estate plan. Well, I just ran down to the bank and I put my kids on the account, or I ran down to the county assessor and I added my kid as an owner. Guys, do not do that. Ryan and I literally want to fall over when clients do that, because what if your daughter gets a divorce? What if your son has a legal issue or is in a lawsuit? They're no longer just your accounts. They are you and your kids. So if you want to lose, a rental property or 30 acres pretty quick, go ahead and put your kids on there and see if a divorce happens or a lawsuit occurs. So do not put your kids as joint owners. If you want to add them as a signer on a trust account, we can add them as a co-trustee on your trust, or we can go ahead and have them as a signer on the account, but do not make them owners on accounts or real property. Issues that come up here, why not do some of these things? You get unintended beneficiaries because we talk about estate planning, and oftentimes we don't spend enough on the durable power of attorney issue. But guys, if you've got asset in your individual names and you become incapacitated and we have a durable power of attorney that's effective, they might change the account beneficiaries. They might try to change, certain items of who things go to when it's in your individual name. When it's in your trust, they can't run down to the bank with a durable power of attorney and say, all right, let's change the PODs or the account beneficiaries. They've got to stick to it. By not putting something into a trust, we also could eventually end up with an ancillary probate, meaning we don't have to go through a full-blown probate, but we're going to have to hire an attorney, file the pour-over will, and at least get a court's order to dump it into the trust. No one wants that. It's no good, no harm, no foul. So last thing is inheritance taxes. We could go buy a $5 million life insurance policy for purposes of paying the estate tax or the inheritance tax. If that life insurance policy is not properly owned by the irrevocable life insurance trust and the beneficiary is not the irrevocable life insurance trust, and that money flows down into the estate, we're going to get taxed at 40%. So that's a great example of why it's so important, whether an ILET's a more advanced plan, but whether it's a revocable trust, an ILET, whatever the case is, titling appropriately the asset is key, because the terms of the trust are not going to apply if they aren't owned by the trust or they don't flow through the trust. And so always keep that in mind, because those are, major hiccups that can occur.
And kind of to piggyback off that, we had a question of how often to take a look at your trust and your overall estate plan. We generally say every 3 to 5 years. I prefer a review every year, just privately between you and perhaps your spouse. But if there's things that have changed, or you've purchased, for example, a new $5 million life insurance policy, that's a great time to come in and say, hey, this is what's happened. What do I do from here? Let's talk about the final buzzer. So at the end, how do we actually win? Of course, the assets need to be titled in the name of the trust, but why do we do that? Or what else do we avoid during our life? As Mitch said, avoid gifting during lifetime. I've had a number of clients say, well, I think my children are living in this rental property. I'm just going to give it to them during my life. It's not a good idea. They can continue to live in that property. If you don't want them to pay rent, that's okay. If you don't want them to pay any taxes or insurance, that's okay too. But if you gift that property to them during their life, they're going to receive your basis in that property. So let's say it was your personal residence from 1990 and you upsized in 2015. There's a lot of appreciation that's happened there. If you gift that property to your child, they take your cost basis from 1990, and if they go and sell it, they have a huge capital gains issue there. Whereas if you distribute it to them via your trust and they receive it upon your death, they get a new step up in basis at the value of the asset at the time of your death. So like it says here.
Yeah, Ryan makes a good point. There's a huge benefit of getting that step up in basis as of the date of death, as opposed to making the lifetime gift. So just be patient and properly title the assets so that, we get that. So great points there, Ryan.
Yep. And it kind of says, let the bucket govern. There's other ways to protect that asset in the long term as well. And this is important too. If the trust says I distribute it to them outright, free and clear of trust, that's okay in certain situations. But you can also build in rules in your trust to say that this trust is still going to own the house. It's technically the trust, but your child can have maybe full control over it, or the trustee can determine what's best for that house at the same time. We want to avoid ancillary probates. So at the outset, I kind of talked about mineral interest and inheritance. We're doing plenty of probates right now where clients have inherited mineral interest. They either didn't know about them or forgot about them, and then it causes a probate. And that's timely, it's costly, and it's just completely unnecessary. Could have deeded those minerals to the trust at the outset. And then don't try to hit a buzzer beater. So what this means is don't wait till the last minute to where perhaps you're incapacitated or your parents are incapacitated and you say, oh, shoot, we need to get these assets into the trust or we need to do some updates. Don't wait. Keep reviewing your estate plan. Keep reviewing your assets as time goes on.
I think transparency is key here too, guys. Before, Ryan goes through some alternatives here, when we have to step in and we've got 2 hours to get something done, or we have to work through a weekend, and this is just being completely honest with everybody on the webinar, our fees are going to change, right? If we're having to rush to a hospital or get everything done in an hour, to be frank with you, we're going to charge the client a higher fee due to the emergency situation. It's much different if we're coming in on a Thursday afternoon at 1 o'clock and having a conversation and we have our normal workflow. But if you're saying, hey, I need you to drop everything, let's get this done, I just want you guys to be aware that's a different situation and the fees are going to be higher. So, be conscious of your money and be efficient here. So I just wanted to point that out and be transparent with everybody.
I've had to go to the hospital for signings numerous times, and it's not ideal by any means. And like Mitch was saying, the travel time and the rush is certainly built into those fees.
And Ryan, it's not a fun experience for you. It's not a fun experience for the family. I mean, that's not an ideal situation in the last minute.
Absolutely not. There are a few alternatives that can kind of put a Band-Aid on things in the interim before all of your trust planning is done, or just a few other options. There are payable on death designations for, of course, bank accounts and IRAs, and even in Oklahoma, there's transfer on death deeds. Again, those don't provide the long-term protection for your beneficiaries, and they don't provide for incapacity during the time that you are incapacitated. Your durable power of attorney can, of course, take those assets and dole them out for your benefit, but having them in the trust ensures that they're there for your benefit and they're protected in the long term. A big issue that's come up within the last 2 or 3 years is cryptocurrency. This one is still kind of a hot topic. I'm doing a probate right now for some folks that had crypto, and there's really no way those wallets to be transferred to the trust because they're just an online wallet. And so with like a Robinhood account, you can set up a designated contact once if something happens to you to where they can get into those accounts. Going along with crypto, all of your accounts, everything we do these days is electronic. So I think it's extremely important to write down your passwords, at least to your phone and to your online banking, brokerage, all of your financial assets, so that people have access to them once you're gone. I think that's oftentimes overlooked, but highly, highly important. Mitch talked on the irrevocable or the life insurance trust earlier. Again, we just want to be sure that the appropriate mechanism is owning those life insurance policies. ILETs are not for everyone. I don't want you to think that we're suggesting ILETs for everyone, but it's just something to think about. And then both of us touched on gifting during your lifetime. That's okay to do, but if you're gifting, let's say, a portion of your business to your kids, generally, we probably want those to be an irrevocable trust, 1 for protection and 2 for control reasons. That's the material we have. It's a good time to think about where you're at and if you need to look at your trust, your funding, the whole plan. This is a good time to do that. We've got a few questions that I think we need to address. So if anyone has questions, go ahead and send those in and we'll be happy to answer them. So there's a question on the step up in basis for the property. Do you automatically get the updated basis? The answer to that is yes. A beneficiary upon death gets that step up in basis. Do we typically recommend? That's a great question. Do we typically recommend a revocable or irrevocable trust? That is a fantastic question. For most people, if you're going to have an irrevocable trust, you're going to have a revocable trust. If you have a revocable trust, you might not necessarily have an irrevocable trust. Irrevocable trusts are great for the people who need them, but you give up control of your assets. The assets in irrevocable trusts are taxed at the highest rate. And so there's definitely situations where irrevocable trusts are completely necessary and appropriate, but not for everybody.
Ryan, I've got one. How far do the Arkansas Razorbacks make it into the NCAA tournament?
Losing the first round to a 13 seed.
Ouch.
Hey, it's better than my Cowboys. They're not even in the tournament.
Oh, we got one more question, Ryan, if you want to take that, and we'll wrap up and let everybody go get some lunch.
If we have heirlooms that we don't want to designate to a specific heir, do we need to list these in the trust? In most trusts, it will provide for distributions of personal property. So it will either say to my spouse and then to my kids. Generally, what happens there is if there's just couches, refrigerators, clothes, etc., the beneficiaries will go in and kind of, I'm a sports guy, so I say go do a snake draft to where the first person gets a pick, second person, third person, fourth person gets two, etc. Whatever people don't want, then they can sell. That money goes into the bucket and is distributed via the trust. That's a great question.
Well, guys, if there's not any more questions, we will wrap up for the day. Really appreciate you guys attending. We take a lot of pride in making sure that we, always continually review things and try to give you guys interesting topics. And with March Madness around the corner, it's always important to make sure your bucket's funded. So I appreciate that, and feel free to send Ryan an email or give either of us a call, and we'll do our best to get back to you as soon as we can.
Thank you all very much.